case on this morning's docket. Case number 108607, Kansas Building Industry Workers' Compensation Fund v. the State of Kansas.
If it please the court, my name is Dorinda J. Mitchell. I'm an Assistant Attorney General in the Office of Kansas Attorney General Derek Schmidt. I represent the defendants, State of Kansas, and Kent Olson, the former Director of the Division of Accounts and Reports in the Kansas Department of Administration. We ask for 5 minutes of rebuttal.
5 minutes is granted.
Thank you. The plaintiff standing to sue must be viewed in the context of what the United States Supreme Court in the Lujan case described as legally protected interests.
Who has standing in this case? Does anyone have standing? What's your position on that? Can anyone sue on behalf of
Yes.
anyone in this case regarding fee fund transfers?
The Attorney General could sue if there was a public wrong, and however, in this instance, the journals of the Senate are
The Attorney
entitled
General
to-
could, because why does the Attorney General sit differently than the plaintiffs here?
because there is no specific discrete interest held by these particular plaintiffs in this public matter. What the legislature did was a public duty. They are required by the Kansas Constitution to provide sufficient revenue to defray the current expenses of the state. Moreover,
But they're not required to take the bankers and the realtors' money.
I wouldn't argue that it is the bankers and the realtors' money.
Who's putting it back
been
into
paid
the fund?
into the-
After it's swept, who's putting it back into the fund? Where's the? You do agree that these funds perform a function,
Absolutely.
and
Your
the
Honor.
funds that went in there, the monies that went into those funds to perform the function, came from the bankers, the realtors, and the insurance companies and self-insurers for workers' comp.
Correct.
And when those monies were swept out of those funds, how were they replenished? Where did they come from?
They came arguably from an assessment that was,
And so why
Applied by
isn't that a harm if you take a fund that my fees have gone into and now that isn't there, and they're saying, hey, you've got to give some more money?
it's arguably a harm, but it is not an actual actionable harm because the journal entries, those individuals, those plaintiffs, those fee payers are obligated to pay for the expenses associated with those funds and with those agencies. That's why they pay the fees. They pay the fees so that the expenses that are attributable to those agencies are then paid.
But they're saying they had to pay twice. In essence, they're saying they had to pay twice. They paid, the money was swept, and they had to pay again. Had the funds not been swept, then they wouldn't have had to pay twice. That's their argument, isn't it?
Well, that
In
may be
essence.
their argument, but that contradicts the journal entry, the journals in the Senate, which are entitled to absolute verity. Those journals say that that money was and I have to interject that we prefer not to use the word swept because it implies that all the money out of those funds was taken, and all the money was not. It wasn't a clean sweep.
Okay.
There was a transfer of a percentage of funds from those fee funds.
Is the word swept okay as to those funds?
Pardon?
Never mind.
Um,
What word would you prefer?
Transfer.
Okay.
A transfer and an appropriation was done at the same time by the Senate and the House, by the legislature, And it was, according to the Senate Journal, for the express purpose to reimburse the state general fund for the accounting, auditing, budgeting, legal, payroll, personnel, and purchasing services, and any other governmental services which were performed on behalf of the state agency by other state agencies which receive appropriations from the state general fund to provide such services. That was the quote in the journal entry.
And as
the-
a matter of fact, that was in addition to the 20% that was earmarked for that very purpose.
It was a part of that.
There was already
percentage.
20% going in there for that purpose, right?
It hadn't been appropriated yet. The omnibus bill appropriated the funds. The statute required that the treasurer account for those funds and put those funds and report those funds and show those funds as part of the general fund. But they had not yet been appropriated because the treasurer can't appropriate money, only the legislature can appropriate money. The House Journal shows that, I'm sorry, Justice
Well,
Lukert, did you
I
have a question?
wasn't sure I followed that, but what you added on helped me understand, but, so go ahead.
Okay. The House Journal showed that the House of Representatives concurred in this omnibus bill of the Senate, and it was passed and signed by the governor
And why is that germane?
because it was a legislative action.
Okay, so that means that in this lawsuit, these plaintiffs lose. Because
It
it
means that-
was an appropriate legislative action. But that's not what we're talking about. We're not talking about who wins or whether it was even appropriate. The only thing before us, as I understand it, is the issue of standing. Do you understand that any other thing is before us?
No, but I do want to raise immunity because I think I need to raise that at
That's
each
not an issue that's before us. Immunity wasn't raised. As I understand it, our petition for review said we will consider the issue of standing. And that just means, do these plaintiffs get to have a tribunal decide the merits of the case? It doesn't mean that they're going to lose or that it was a legislative act or whatever. It just means, can they get into court, doesn't it?
It does, but standing has to be evaluated in the context of the available law. You can't say that someone has standing to articulate a petition that is in violation of the rule, for example, that the journals have absolute verity and are entitled to absolute verity.
That leads to the next question. As I hear you, you're saying that on the federal elements, the third one is that the injury can be redressed by favorable decision. I hear you saying no, there's no redress. But do we use that federal model, or do we use the state test, which is just a cognizable injury and a causal connection?
The causal connection is also not appropriate in this case. They do not have a causal connection in addition. So even if you apply the federal standard, which I understand from the Morrison
Help me
case,
here.
the federal standard is
Help me
used.
here. They take the money out of this fund. They transfer and appropriate it. The funds aren't there. The fund then assesses additional fees, and people are writing checks. The workers' comp insurers are writing additional checks that they would not have had to write if the transfer had not taken place. So why isn't their injury, the additional monies they have to pay, but for the transfer of funds? And if that isn't a causal connection, I guess I don't understand it.
Because the difference is that it's an appropriation versus an assessment. The plaintiffs are complaining about an appropriation. But yet it's the assessment of those by the agencies that is in fact the cause of their injuries. It's not the appropriations. The district court agreed with this analysis and gave the plaintiffs an opportunity to amend their petition, but the plaintiffs did not amend, and their opportunities now passed. They did not sue. They sued the Director of Accounts and Reports, and they sued the Save Kansas, the executive branch, neither of which had made the appropriations that were complained about in the plaintiff's petition.
Okay, now give me that again. You're saying Mr. Olson wasn't a proper party defendant?
No, he's not. He
And
did
so how
not
does
cause the injuries.
Excuse me, Counselor. So if we have sued the wrong person, that deprives the plaintiff of standing?
Because of the causation element.
Okay.
He did not cause the injury complained of. The causation factor is wholly lacking. The cause of the injury was the legislative action. That's what plaintiffs claim. The state of Kansas, the executive branch, and the Director of Accounts and Reports didn't cause the injury about which the plaintiffs claim.
And that's because the funds could have just declined to reassess? They didn't need to make another assessment, is that your argument? So the harm came from the assessment, not from the transfer and appropriation?
That's a part of our argument. The assessments either weren't necessary, or there isn't anything before the court to tell the court what it is about those assessments that would be appropriate in a legislative or in a litigation of this sort. The Director of Accounts and Reports cannot legislate. He cannot appropriate. So the defendants in this matter didn't commit the action which plaintiffs say aggrieved them. And the third standing requirement of redressability is also lacking. Neither the state executive branch nor the Director of Accounts and Reports can appropriate monies to redress the grievances complained about by these plaintiffs. They can't appropriate money. They can't refuse to follow the dictates of the legislature.
And I think we understand that argument, but did you answer my question as to why that's one of the issues for us? I mean, that's the federal law of standing, right?
It's my understanding in the Morrison case that the federal standards, the federal standing requirements have been adopted by this court. And as you pointed out, Justice, the Court of Appeals did discuss the injury in fact requirement, and I think I answered the question that that injury in fact requires a discrete or a distinct injury to the particular plaintiffs. Paying the expenses of state agencies is a public duty, and it cannot be said to impact uniquely or discretely on these particular plaintiffs. The Court of Appeals, we believe, found incorrectly that the court could assess the reasonableness of an appropriation, and we disagree. The Court of Appeals cannot assess the reasonableness of the appropriation in this regard. I believe my time's up.
Do we have any further questions? Thank you, counsel.
Thank you.
May it please the court, Mike O'Neill with Gilden and Hayes on behalf of the plaintiffs, which, as this court knows, are a number of entities who were allegedly aggrieved by fee sweeps proposed and passed in the 2009 legislative session. So
how do you answer counsel's argument that it was not the transfer or sweeps that caused the injury, but it was the following or consequent assessment by the funds is the injury?
Yeah, it truly is a but-for, and at this point, as you know, we haven't gotten past really the first base. This is a motion to dismiss, so what you know is basically what's alleged in the petition. And so turning to the allegations of the petition, what has happened in this case is that you have money paid into a fund for a specific purpose. The legislature and the governor's office proposed to sweep that and use it for a general purpose. The consequence of that, perhaps at that point no injury, the injury occurs when the agencies do what the agencies by statute are allowed and essentially required to do, and that is replenish the funds with sufficient funds to accomplish the purpose for which the fund was created.
Did all three do that?
And
Wasn't
they-
one of them did not do an additional?
Yeah, that's a good question. The clearest case, obviously, is the workers' compensation fee fund, where individuals who pay into that fund are assessed essentially a premium, a percentage of premium. And then when these fees were taken, the insurance commissioner sent a letter to all of them saying, because of this legislative enacted sweep, we are going to have to go back and reassess you again. So that there's a clear connection of the dots there.
The realtors is the problem here.
The realtors, there was a case-up fee fund that was taken. And in that particular case, while there is not a direct reassessment, it raises the issue of who would be entitled to the credit where that money is taken out and then perhaps never used for any purpose. Because the remedy for a fee that is too great is not that it escheats to the state, it's a refund of that to the people who paid it in. So with the realtors, I would concede that it's more a credit issue than it is that they had to dip into their pocket and pay a second time.
But just so I'm absolutely clear on the facts, they pay a fee.
They
And their
do.
fee, every year, license fee, and their fee did not change because of this transfer or sweep.
In that particular one, it has not.
And your only argument for damages is that, well, their fees would have built up in excess and that would have belonged to them, perhaps.
Yeah, and it is really, with whether it's called a trust fund or not, the legal application of these funds, or they're held in trust for a particular purpose. And let's assume that at some point in time, that trust comes to an end. And we assume at some point all funds will come to an end. The question arises as, when it comes to an end and there are balances, where do the balances go? By law, we believe that if it would go to the state for a purpose that's a general application, it violates the Constitution. The remedy is a redistribution to those who paid into the fund. We're not there yet, of course, but the standing issue with regard to the realtors is that they currently have a credit. And to the extent that money is not reassessed.
Well, but when we're looking at, when we're looking at the elements, let's say the federal, we're talking about an injury in fact. Here we're talking about an injury in speculation. And we're talking about, the third is an injury that can be redressed. So it seems like we're too speculative with the realtors to give them standing.
And just to be perfectly candid about this, the main issue here is getting a determination from the judicial branch as to the propriety of not only these types of sweeps, but sweeps in general. What are the rules of engagement?
Can I jump in there? Because
Yeah,
that,
exactly.
to me, I think hits on at least what, to me, presents the heart of this case. And I think you identified this in one of your filings when you just summarized the state's argument as the state believes the court lacks subject matter jurisdiction over this argument. And I do think this is read back into standing, whether we call this redressability under a federal standard or our state language always talks about having a sufficient stake in an otherwise justiciable controversy. And aren't we really talking about justiciability? And why is this justiciable? I mean, as I understand the state's argument, saying this, you're complaining about an appropriation. Appropriations are the grant of power to the exclusive legislative branch, and basically, while we may have sympathy with the equities of your argument, you're standing in front of the wrong branch of government.
Yeah, and so I guess it gets back to the question, if if there's no one, that would essentially suggest that there's no one to challenge a legislative appropriation that literally steals money from funds that were created by the same branch of government for a particular purpose.
Well, that's the question, though. If this really is a political question, which is non-justiciable,
It
that
is.
is the result. So my question to you is, why isn't this a political question? Why is it justiciable?
Yeah, and a little history here, because the roadmap as to why we felt like that this was something that could be pursued is it's not the first time this court has looked at this. That's the Panhandle Eastern case from 1958, which was exactly the same situation with a couple of notable exceptions, which I'm happy to talk about, because 1958 was Administrative Procedures Act, and it was pre-statute that dedicates a certain percentage of these fee funds to be sent over to the state for purposes. That's the 20% fee fund that fee sweep, if you want to call it, or transfer that Justice Johnson was talking about. But here it was, the legislature was about to take action to take funds and use them for a general revenue purpose that far exceeded the cost or the scope of why the regulatory agency needed the funds. And that was struck down. So Panhandle Eastern has been the law of the land for many, many years. The legislative response to Panhandle Eastern was to go in and say, okay, well, now we'll start putting in the statute that all the funds that are collected, 20% of them will go to the state. That's been the law for many, many years, and it's important to point out we're not contesting that. As you noted, Justice Johnson, in the case of the realtors and the bankers, the sweeps in 2009 were in excess of the 20% statutory sweep. We do not contest the 20%, we contest the excess, because it bore no relationship whatsoever, we allege, with the actual costs of administering those funds. In the case of the Workers' Compensation Fee Fund, the history on that was identical sweeps were done in 2002, which caused the Attorney General to opine in Attorney General Opinion 2002-45 that this appears to be a violation of the Panhandle Eastern Doctrine. And what the Attorney General said is we're not going to go so far as to say right here and now it's unconstitutional because it's a fact question. If the legislature is going to claim that these were sweeps to pay for the actual costs of administering these funds, then we need to know. We need to have a factual determination of whether, in fact, the money was used to reimburse the state for actual, identifiable, calculable costs.
What constitutional power was the legislature exercising when it adopted these sweeps? Was it the power of appropriation?
In general, it's the power of appropriation, and what we've made it clear, we do not claim that the legislature is powerless to pass legislation or appropriations that may be challengeable as constitutional. They can do that all day long, but they cannot, by boilerplate or otherwise, deny the judicial branch of the opportunity in a declaratory judgment action to see whether the appropriation in fact violated constitutional protections. That's exactly what we're arguing.
Well,
this is a declaratory judgment action.
What constitutionally protected right did this appropriation violate?
The first one that comes to mind is Article 11, Section 5 of the Constitution, where you're essentially turning a fee for a particular purpose into a tax.
Right.
And so your appropriation, if you're going to do that, call it a tax and just say, okay, now we're going to administer a new tax.
Right. So it strikes me that, and again, I may be wrong, so convince me I'm wrong, but it strikes me that the gravamen of your claim is that this was an unconstitutional exercise of police power. But what you're really complaining about is the power exercised by the agencies to increase the fees in response to the legislature's appropriation. In other words, the action of the legislature did not, that's not what raised your client's fees. There's a but-for connection, I see that. But I'm interested in what powers we're talking about.
We're challenging the power of the legislature to put into practice and actually take money for which there is a valid constitutional challenge on the basis of Article
Okay.
11, Section 5.
You are challenging the appropriation then?
The power, we may be splitting hairs here. We certainly are not challenging the fact that the legislature can make enactments. What we're challenging the state's claim is that there are, in appropriate cases, remedies for how that operates in practice. And here, they're literally making a legal fiction, doing something through legislative enactment that if anybody else did it, they would be charged with a crime. And this is a serious, if there is no
Legislatures
remedy,
do that all the time, right?
if there is no remedy, it's frightening. There was fee sweeps within the last 2 years, one affecting the judicial branch, disciplinary fee fund, and the Attorney General's concealed carry licensure fee fund. And it was only through a veto. The Attorney General himself said, please, Governor, veto this, because if you don't, it's a tax on gun owners. It's exactly the same argument we're
So
making.
to accept your position, would we be required to overrule or at least disapprove some of the language in the court's precedent that talks about it's the exclusive power? The legislature has the exclusive power to decide how, when, and for what purposes to appropriate money. And again, I'm driving at this political question and whether it's even justiciable.
Yeah, you would have, I would turn it, I guess, another way. You would have to overrule your own precedent to find that we don't have standing.
The Panhandle case.
The Panhandle case, Watson versus City of Topeka, where if you can identify a identifiable injury, and I think it's really, seriously, I don't think there's any contention that these parties can identify a particular unique damage to them that is not visited upon the entire public. So the precedent, we framed this litigation based upon solid Supreme Court precedent, and one federal case that we haven't talked about yet, and that is the Sack and Fox versus Pierce case, because you make this argument. There's a middleman here, and in our case, it's the agencies that, in response to having funds that they have control over swept, they then go back and assess, as the statute allows them to do, the licensees. In Sack and Fox, you had a tax that was imposed on distributors, and the tribes, who were the consumers, the retailers, complained, and the standing issue came up saying, well, Sack and Fox, you can't complain because it's the distributor that was taxed. Sack and Fox said, yeah, but the distributor just passes that tax on down to us. The court had no trouble saying, you're right, you really are the damaged party. I see really no distinction at all, and neither did the Court of Appeals, in the Sack and Fox reasoning and the precedent established there and what we're dealing with here in order to satisfy standing.
And I know we're way down the road here, but what happens in the end here, given your version? What occurs if you prevail?
Yeah, there are, obviously what we've pled is we want an order that defines what the rules of engagement are in terms of how you can utilize basically private funds that were contributed to by private entities, what the rules of engagement are. Ideally, the home run would be in an order that says, really, those funds ought to be restored to those funds. But that's not all we're asking for. An adjudication that those sweeps were unconstitutional through a declaratory judgment action. If you were to opine that they were void and should be returned, obviously that's something that the legislature could do, but we may have to go through the claims process to get that done. You'd have to, in a new legislative session, you would have to waive the opinion to the legislature and say, what you did in 2009, you need to restore those. The primary interest of these parties is what happened in 2009 was wrong, this is why it was wrong, and a signal and precedent to guide future legislators, because there have been sweeps. We've been in this litigation 5 years, and there have been identical types of sweeps since. They're not before this court, but the same nature of sweeps are taking place and will continue to take place unless there's clear guidance from the court.
Along those lines, maybe this is neither here nor there, but just for my own clarification, do you know, does it require legislation to effectuate one of these sweeps, or does the allotment power, is there any relation between the allotment power and these sweeps, or is that something completely different?
Allotment would affect only approved legislation, approved appropriations in the current fiscal year, and a reduction.
So it can't
of those.
impact any segregated fee funds. I
Having
think that's
5 seconds to think about it. That's correct. It wouldn't affect that. And how it happens, and this is the other part of the language from Panhandle Eastern, is there's boilerplate language that goes in all of these sweeps now, because in order to get past the Panhandle Eastern test, you've got to at least facially say that you're not going to admit that you're sweeping this to put it in the general fund to spend on child care facilities. You've got to say, in order to pass the Panhandle Eastern test, at least facially, well, we're doing this to reimburse ourselves for the actual cost of administering the fund. And what we want to get to in a trial of the action on the merits is to test whether, in fact, $2.355 million was necessary by the state of Kansas in 2009 to reimburse for the cost of administering a fund that is administered by the insurance department, a totally separate branch. By no stretch of the imagination can you really say that it costs $2.355 million to do that. But to the state's point, that's what the legislature said, and the state would have you say, well, it doesn't sound believable, but we cannot look beyond the language in the statute. And so if the legislature says it, the judicial branch, has no power, authority, jurisdiction to look behind. And no party, no attorney general, no private citizen has the power to look behind that pronouncement and say, factually that's incorrect. In fact, that's just not true at all. And that's what we're asking for, is the opportunity to show that this was not for a legitimate purpose, but rather just to fill a budget hole that we all know existed in 2009. Total sweep was around $29 million. These are just 3 pieces of the sweeps that were done that parties came to us and asked us to pursue.
Can I clarify
Yes.
your unconstitutional tax argument?
Yes.
You're saying that the legislature set up these funds to be administered by the agencies and funded with fees that were designated for the purpose of doing the business of the fund.
Yes.
That the legislature then took those monies and used it for a purpose other than which they authorized the fee assessment authority. So that was tantamount to creating a tax, because they took fee funds and used them for tax purposes.
Right.
And that was unconstitutional. Why?
Again, if you review Article 11, Section 5, I can't quote it right off the top of my head, but in enacting a tax, you must do so with a clear piece of legislation that clearly states the purpose for the tax, and that the use of that tax can be used only for that purpose.
You can't
Just
tax as a subterfuge, right?
Exactly. Also, I'm sorry,
I was
Chief
just saying,
Justice.
it's a conversion.
A conversion. And the other thing that's akin to that, but might be a little bit different, is the cases that talk about the fact that when a regulatory agency collects costs that are that are more than the cost of actual regulation, then it becomes an abuse of the legitimate police power of that agency.
The enabling statute.
Yes, thank you. And so we really have a two-pronged approach to this, and so the remedy for fees that are more than what is needed or ever would be needed is not a sweep, but a refund or a reduction moving forward. And that
Can I
did
take
not
you
happen.
back to our regular way of looking at standing without bringing in the political question? Seems to me we've got a couple instances here of associational standing.
We do.
And So those associations didn't themselves suffer an injury in fact. So how do we?
Yeah, this is, I guess I would refer to the Sierra Club versus Mosier analysis that you set out on associational standing. And here, and again, all you really have in front of you are the pleadings. In other words, the petition. We tried very carefully to satisfy what we understand the associational connection to be. These are associations that essentially have the lion's share of the market for realtors and bankers, and their core mission is to look out for their members on issues that are very much within this would be in their wheelhouse to protect their licensees from these types of sweeps. And so we believe that we have shown the necessary elements of associational standing. And certainly when I look at the Sierra Club versus Mosier case, I think it's even a stronger, I don't disagree with the finding there, by the way, but I think an even stronger case for associational standing it exists here than even in the Sierra Club case.
And
There are others, but that's the one that comes readily to mind.
And what are the elements of standing, just regular standing for the individuals?
Well, that you have a identifiable injury, that there is causation, and that there is the court can fashion a remedy for that. It is the traditional common law. The court, this was
So
interesting.
you're just, what I'm getting at is you're saying that it has to be redressable, the third element of federal standing.
To be honest, I have not thought about the possibility that we have a standard that's somewhat other than the third prong of the federal standard. I've always accepted the third prong as being
Okay,
one of the
let's
requirements.
accept that and explain to me how we can fashion a remedy that will assure that Acme Insurance Company providing workers' comp will get its money back.
And again, I would stress that is only one of the remedies we're asking for. The paramount remedy that we're asking was in the DEC action itself to rule that under these circumstances, that type of a sweep is void as being unconstitutional.
So how?
So the precedent.
How Acme can be redressed is if we declare that was wrong, then we can cut off future assessments to that company. Is that
Yeah,
what you're saying?
kind of the next step is us. I mean, one of the first things you would do is you go back to the next session of the legislature and say, we have a claim against the state for $2.355 million. Legislature will either accept it or reject it. I mean, so it's not that you're guaranteed a remedy. It's that it's, as the Court of Appeals pointed out, is that there is a redress that you have standing to claim. Whether or not you end up getting it or not is really beside the point. It doesn't affect the fact that you might actually get everything that you want is not a requirement of standing. It's only that there is a remedy. And one of the key remedies that we were asking for short of refund is that declared void, clearly set out the rules for sweeps. By the way, not to confuse things, but there are sweeps and then there are sweeps. If you've got funds that are currently within the control of government, but they may be over here, we don't dispute how the power of the legislature to move it from here over here, because they had power over it. It was state money. It had been converted to state taxpayer money. These are different funds. These are actually funds that are paid in by private citizens or companies for a particular licensing and police power use that are just being promiscuously moved for purposes that have nothing to do with the underlying, and that's the sin that we were wanting to do away with, using the excess police power argument and the Article 11, Section 5 argument. I'm way past my time, so are there any other questions?
Any more questions? Thank you, Counsel.
Thank you.
Thank you. Article 2, Section 22 of the Kansas Constitution provides that for any speech, written document, or debate in either house, the members shall not be questioned elsewhere. Yet that's precisely what this lawsuit asks this court to do. It asks this court to question the Senate Journal that said that these appropriations were for expenditures of these agencies. The Panhandle case is also inapposite. It should be noted that the court in the Panhandle Eastern case said that the assessments were without clear authority. The plaintiffs in that case sued the KCC. The legislature in 2009 has already made the factual determination required by the Panhandle Eastern case. The Senate Journal, again, supplies that specificity that the Panhandle Eastern case required. The Sack and Fox case is also inapposite. It dealt with appropriations, and the Director of Accounts and Reports is in no way a distributor, as the Court of Appeals tried to make the case. And the Secretary or the Director of Accounts and Reports did not involve himself in any way and was not involved in the assessment of those fees. The Attorney General's actions in going to the governor and asking for a veto was the proper way to participate and complain about legislative appropriations. He went to the political process and went and asked the governor to exercise his political authority as a part of the political process.
And if the governor does that and the governor vetoes, and then the legislature has enough votes to override the veto, are we done?
Yes. Yes, I believe so. And that's why we ask that you dismiss this case, that you affirm the decision of the district court, and that the Senate Journal be given the absolute verity that the case law says to which it is entitled.
Is that true even if it violates Article 11, Section 5?
I'm glad you raised that. Article 11 pertains to ad valorem taxes. Those aren't at issue in this. Even if we claim that they are fees, and even if they are interpreted as something other than fees, that article pertains, one, to the assessment of taxes, not at issue here. At issue is the appropriation that was made by the House. And the second reason that constitutional provision does not apply is that it pertains to ad valorem taxes. These aren't taxes on the value of property.
Let me ask a broader question. Is that true if there is a allegation of a constitutional violation? I mean, would that be the question we're asking at a motion to dismiss stage, rather than getting to the merits of whether or not a constitutional claim that is being made is correct? So at this stage, does a party have a right, standing to argue that an act of the legislature is unconstitutional if that party has an individualized specific harm?
I would argue that it still has to be justiciable. There still has to be some case or controversy. If there is no constitutional provision that applies, then they don't have standing to complain about that particular provision of the Constitution.
But is all that is required at this stage an allegation and a motion to dismiss? Do you think we weigh the merits, ultimate merits?
It cannot be an allegation that presumes the Senate Journal to be inaccurate or invalid, the way that the plaintiffs have claimed it, because then that upends the presumption that's required of this court by the long-standing cases that say that those journals are entitled to absolute verity.
You're saying the legislature just sort of has carte blanche to put a fig leaf on whatever they do. That sounds like what you're arguing.
Excuse me.
If if they say in those journals that that they are for a legitimate government purpose, then I would say yes, but the remedy is, as always, to go to the legislature and argue and complain as a part of the political process.
I don't understand that argument because, and the one that's been going through my mind while Mr. O'Neill was talking was State Ex Rel. Stephan versus Carlin, which was the multiple subject. You had an appropriation plus you had general statutory language, and the court said you can't do that. Because it doesn't seem to me that the legislature could do in a journal entry with the passage of that bill, oh, these are all the same subject. And that somehow you can't challenge a legislative action once the legislature has sort of declared that these are all under the same subject. I mean, that doesn't make sense to me, and it doesn't seem to follow our case law. You see what I'm saying?
I do believe, and I believe that Judge Tice had a problem with that. He was concerned about the germaneness of the appropriations. However, he interpreted the statute that required the treasurer to set aside, not appropriate, funds as an appropriation.
And I'm not worried about the two subject
Okay.
challenge. That's something
Okay.
you guys can talk about later if you get there. I'm really trying to follow up on Justice Stiegel's question about the legislature being able to put a fig leaf on everything. They can't. I mean, they couldn't put in a journal entry that a piece of legislation is all the same subject when they clearly aren't. For example, an appropriation and a general subject thing, you just can't do that. And they couldn't say, oh, well, this is all one subject, so we're okay. I mean, it's still going to be subject to a constitutional challenge, right? Just like State Ex Rel. Stephan versus Carlin.
Well, in State Ex Rel. Stephan, the part of the case that was against the legislature, that challenged the legislature, was dismissed.
No, that's different. That was one
Okay.
of my old cases.
Why can't the Senate Journal simply say, we declare this law to be constitutional, period, and we're done? Because it
Because
sounds like that's where you're kind of moving us.
I believe, Your Honor, that this court is the ultimate interpreter of the Constitution. I believe you have the right to interpret the Constitution. My argument in this case is that there is no constitutional issue except with regard to the obligation of the legislature to pay the expenses of government, which they did and said they did in their Senate Journal.
To put it in terms we're more used to thinking of, perhaps, the legislature made a finding of fact that these are costs that were incurred, and anything that any type of a factual type of finding that they would make would not be subject to our review. But any legal conclusion they drew about that, such as it was constitutional to do this, would be. Is
Yes,
that a fair way to draw the line?
I think that's a good distinction.
Did I understand you to say very early in your first round that the challenges that Mr. O'Neill's making to the constitutionality of the action, the Attorney General could have made as a State Ex Rel. Type of case?
If we didn't have that Senate Journal saying that these expenditures were for a legitimate government
Okay,
purpose.
so that's kind of a factual thing, I guess, but my point is, basically, you're conceding this is not a political question, because even the Attorney General can't bring a lawsuit that's on a political question type.
No, I do believe this is a political question in this case.
Then how can the Attorney General have standing to be able to bring this action?
He would have the standing to bring an action in the right case, to complain about the expenses and the expenditures of government.
So
Or-
you're kind
or
of amending the
constitutional.
answer to my very first question, who has standing? It's no one.
I
Yeah,
think I
that's-
have to
That's your
amend
answer,
it.
not the attorney, okay.
This is just a political question or otherwise non-justiciable.
Correct. And we made that argument at the district court level.
Yeah, any further presentation, counsel?
No, thank you, Your Honor.
Any
Unless
more
there are
questions?
questions.
I see none. Thank you.
Thank
We Thank
you.
both counsel for your arguments this morning and this afternoon. And the court will take this matter under advisement.